the electronic numbering. It is conceded that the document is a warrant, but it is said it is not a warrant for the purposes of the Act, since being signed only by the public prosecutor is not a judicial document, as required by the definition in Section 26. There is, I think, a simple answer to that argument. The definition in Section 26 of the Act is inclusive. A warrant is defined as including any judicial document authorising the arrest of a person accused or convicted of crime. There is nothing in the Act or the treaty which requires the warrant to be signed by a judge or magistrate. So the simple point was that the 1870 Act did not require a judicial decision. So the fact that a non-judicial warrant could support a request for extradition from the state takes one no further forward. We go back to the divisional court decision. Paragraph 35 we've already looked at. That's the paragraph where the divisional court suggests that the words judicial authority have two different meanings within the framework decision, and we say that cannot be right. The court supports that conclusion with the reasons that then follow. In the first place, paragraph 36, it is clear that the term judicial, as used in the several member states, does not refer only to a judge who adjudicates. Each member state recognises the threefold division of functions and powers within each state between the legislative, executive and judicial powers or branches of the state. It is a fundamental in each member state that the judicial branch is independent of the executive and legislative branch. Although no member state should for a moment consider that its Ministry of Justice was part of the judicial branch, many states, as is clear from the judgment in Shisa, consider that the exercise of judicial power is not confined to adjudicating. In some states, it encompasses the function of investigating, where this is entrusted to an investigating judge with the characteristics described in Medvedev's, so far so uncontroversial. Although the status of a prosecutor is more debatable, a prosecutor does, in some member states, come within the term judicial authority. In some member states, the prosecutor is recognised as part of the corps judiciaire, and then there's a reference to the judicial council, comprising both prosecutors and judges, and a reference to the French example. There's a considerable diversity within the common area for justice as to whether prosecutors are judicial authorities. It's relevant to consider the status of the prosecutor must enjoy independence in the decisions he must take, though the functions of a prosecutor are distinct and separate from those of a judge. And there they actually quote the Bordeaux Declaration. Although a prosecutor is in many member states part of the executive, that independence gives the prosecutor special status. Now, with great respect for the divisional court, we say this paragraph 38 is wholly confused because although seeking to found on Shisa, the divisional court has failed to understand the point of Shisa, that Shisa is saying, yes, there is a diversity of practice in different member states, but there are limits to what is an acceptable judicial authority, and the limit is drawn by the requirement of independence from the executive and independence from the parties. And that principle is simply not drawn out at all by the divisional court. And of course, we say the Bordeaux Declaration is completely contrary to what is suggested here. So we say the first reason does not hold water. Secondly, says the divisional court, the explanatory memorandum, and this is the point about the original Commission proposal. Here they cite the explanatory memorandum, which was attached to the original Commission proposal that we've seen, and its reference to the term judicial authority not being limited to judicial authorities as such, but also including the prosecution services. And they refer to the 1957 Convention. You already have my submissions on that point, and we say, for the reasons discussed earlier, it is transparently bad. And indeed, the legislative history of the framework decision shows the opposite from what is suggested here.
So that is written in the context of the original
proposal.
Draft Article 3 with the definition?
Yes, that's right.
Do they actually mention that Article 3 was dropped?
No, they don't mention it. So the divisional court relies on that when it never made it into the final text. So then paragraph 40, thirdly, if the term judicial authority were confined to a judge who adjudicates, it is difficult to see what purpose Article 6 of the framework decision would have served. The article must have been intended to allow member states to designate authorities in their state which were judicial authorities having regard to their own national law, given the diversity to which we referred at paragraph 38. Again, with respect, confused. because the purpose of Article 6 is clear. The purpose of Article 6 is that member states, from amongst the pool of authorities which are properly to be considered judicial, member states are to select the particular authorities whom they designate to issue warrants. The purpose of Article 6 is not to permit states to designate authorities that are not properly judicial. Now, they can designate them if they choose, but other states are not obliged in that case to execute their warrants. So again, we say that is a bad point.
So, I mean, that would give the French an opportunity to say, well, the juge d'instruction.
Yes, and the juge d'instruction passed muster in Medvedev and doesn't fall foul of the problem of independence. But this, as I've said before, is a simple, straightforward case because we deal here not with the juge d'instruction, but a simple common or garden prosecutor. Fourth, it cannot be said that the term judicial applies only to a judge who adjudicates. The different European traditions recognise that others, including prosecutors, can be included within that term for various purposes. It's therefore entirely consistent with the principles of mutual recognition and mutual confidence to recognise as valid an EAW issued by a prosecuting authority designated under Article 6. To do otherwise would be to construe the word judicial out of context and look at it simply through the eyes of a common law judge who would not consider a prosecutor as having a judicial position or acting as a judicial authority. Now, that in part seems to be a repetition of the reasoning of paragraph 38, but the suggestion that the placing of a limit on what is regarded as a judicial authority by reference to independence is in some way a parochial common law position is, of course, inconsistent with the case law of the European Court of Human Rights. It's a striking feature that the divisional court doesn't grapple with the centrality of the concept of independence at all here. The distinction it appears to be drawing is between a judge who adjudicates and some other sort of judge, and we say that is simply missing the point. Of course, anybody who makes a decision is adjudicating. The public prosecutor is adjudicating when deciding to issue a European arrest warrant and deciding that the proportionality test is satisfied. But what the public prosecutor is not doing is exercising a judicial authority because she is not independent. The court then cited the Goatley case for the point that the mere description of the executing official couldn't frustrate the purpose. And that in that case, they were satisfied that the prosecutor in the Netherlands performed a function as part of the judiciary. But again, we say that has no bearing on the position in Sweden. And then at 43, they expressed...
No, sorry, it's too quick for me.
Sorry.
42, Goatley. When you're happy with Goatley, are you, on the basis that the particular functions there, as set out at the bottom of the page, are judicial?
My Lord, I'm in no position to comment on the precise position of a public prosecutor in the Netherlands. The key question in my submission would be whether the public prosecutor in the Netherlands is independent, both of the executive and of the parties. If he is, he qualifies. If he is not, he does not. Now, that's not a question that's addressed in Goatley, and it's not a question that's relevant to this appeal. The key...
Sorry to interrupt. Goatley was actually a conviction case where, if I recall rightly, there had been, according to the sheriff, some sort of decision. Perhaps he was referring to the original conviction by a court. But anyway,
maybe so. But my Lord, the decision in Goatley is in the supplementary bundle. If your Lordship would like to look at it.
I think it's at tab 17 as well, isn't it?
Unfortunately, my Lord, that's the wrong one.
Yes. Oh, I see.
The right decision in Goatley is in the supplementary bundle at tab 142. The key passage is at page 5914, paragraph 16. So in this passage we discuss the issues raised in the Ground Appeal 4, which seek to challenge the validity of the Part 1 warrant issued in the present case. The essence of the complaint is that the person who issued the warrant was Mr. S. Temple, described in the English translation as Chief Attorney General and Deputy Public Prosecutor of the District Public Prosecutor's Office in Leeuwarden. It's alleged he could not properly be regarded as a judicial authority. Then they record the submissions of Mr. Bovey at paragraph 16, submissions of the Lord Advocate, and then the discussion at paragraph 24. While we considered the authorities relied on by Mr. Bovey, in our opinion, none of them supports the approach he urged on us, which was to put into question whether the Netherlands had properly carried the framework decision into domestic law. In Wright and Scottish ministers, the court said it is to be taken that if the UK has decided to enter into extradition agreements with a foreign state, that will have been done only after the government of the United Kingdom has satisfied itself that the system of criminal justice operating in that foreign state is worthy of confidence. That was a bilateral treaty. Same principles apply a fortiori to a case under the framework decision. There's no merit in the argument the warrant is invalid because it's been issued by a person described in the translation as the Chief Attorney General and Deputy Public Prosecutor. The danger of Mr. Bovey's approach is to look at this description with Scottish eyes and say because a person so described would not be a judicial authority in Scotland, it must necessarily make the warrant he issued invalid. That is fundamentally wrong for a number of reasons. And then they say they have to have confidence that other states will act in good faith. They don't say the Netherlands have not acted in good faith. It doesn't say he wasn't properly convicted. They're not acting improperly, and the court should not seek to question the authority of the Chief Attorney General or look behind his appointment. Now, with respect, we say that none of those propositions is really of any relevance or assistance. It simply doesn't really begin to grapple with the point. And then at 26, they say that the carefully worked out scheme ought not to be frustrated by mere descriptions of the executing officials. Again, not really addressing the points that we make at all. And then at 27, they say in any event they had information and they think he performs judicial functions.
But begs the question as to what one has putting confidence in, doesn't it?
Yes, indeed. And in my submission, this reasoning just simply doesn't really take the matter any further. So.
I mean, it may be you don't want to say it, but it may be that your view is, or your submission is, that this decision is incorrect.
Well, my lord, it may well be incorrect. It's really not addressing any of the arguments that we've made. I mean, its reasoning, with respect, is not terribly impressive. Then, going back to the Divisional Court judgment, the Divisional Court addresses the case of Enander, and in Enander the court had concluded that it was for each member state to designate its issuing authority, and that couldn't be questioned by the English court. They say it's not necessary for us to consider Enander further in the light of the principles which, with the benefit of much fuller argument, we've endeavoured to set out. Important to emphasise the issue in that case related to the issue of a warrant by the police for the service of a sentence. Maybe the circumstances relating to a warrant issued for the execution of a sentence are different. Although the approach in Enander is one that will ordinarily apply, the designation under Article 6 does not, in our view, always compel the recognition by another member state as conclusive. If the authority is self-evidently not a judicial authority within the meaning of that broad term in the framework decision. And then they refer to the status of a Ministry of Justice, and that it had been said that the designation by some states directly or indirectly of the Ministry of Justice was contrary to the terms of the framework decision. They say there appear to be no instances where the Commission has taken action. I've made the point the Commission doesn't actually have the power to take action. For example, if a warrant was issued by a Ministry of Justice, which the member state had designated as an authority under Article 6, it would not, in our view, be a valid EAW under the framework decision. Now, this passage we submit is important because we say here the Divisional Court rightly accepted that that under the 2003 Act, the mere fact that another member state had designated an authority could not be conclusive of the question whether that was a judicial authority. There is a question of substance, it's a question of precedent fact, which the English court has to consider. Is this a judicial authority or not? And if it is not a judicial authority, then the warrant is not valid. And we say that the Divisional Court was right to reject Enander on that point. and was right to say that that is an inquiry that must be undertaken by the National Court.